For those of you who don't know me, my name is Caris Craig, and I'm a member of the law faculty at Osgoode Hall Law School at York University. And I'm a member of the organising team for this SSHRC-funded conference on tackling technology-facilitated violence, which is now a series of online workshops and public events on this important topic. Also on the team are my colleague, Professor Sonia Lawrence, who's going to be moderating today's discussion, so you'll be hearing from her soon, as well as the University of Ottawa's Professor Jane Bailey, and the organising minds behind this whole project are Susie Dunn and Pam Rick. I also want to thank Amanda Turnbull and Michelle Liu for all of their assistance in bringing us together. So we really appreciate everyone taking the time to be here with us this afternoon for what I'm sure is going to be an excellent keynote lecture and a discussion panel on the topic of discredited data, epistemic violence, technology, and the construction of expertise. Before I introduce you to our keynote speaker, I do want to acknowledge that I am speaking to you from the area known as Takaranto, which has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It is now home to many First Nation, Inuit, and Métis communities. The current treaty holders are the Mississaugas of Credit First Nation. The territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. So in the spirit of welcome, I'm delighted to extend a warm welcome to our speaker, Professor Ngozi Yokodaki. She is an assistant professor of law at Cardozo School of Law at Yeshiva University, where she researches and writes in the area of criminal procedure, critical race theory, evidence, technology, and racial justice. Before joining Cardozo, Professor Yokodaki served as a law clerk for Justice Madlanga of the Constitutional Court of South Africa and for the Justices of the Court of Appeal for Ontario. She graduated with a BCL LLB from McGill University's Faculty of Law, where she was the recipient of several prestigious scholarships, prizes, and awards. She went on to earn her LLM from Columbia Law School, where she graduated as James Kent Scholar. Professor Yokodaki's articles are published or forthcoming in the Criminal Law Quarterly, the Kansas Journal of Law and Public Policy, Connecticut Law Review, and now I believe for the paper we're going to be hearing more about in a moment, the Cornell Law Review. So on maybe a bit of a more personal note, I actually first met Ngozi at a conference in New York, the Race and Intellectual Property Conference, when we were put on the same panel. And after hearing her speak passionately about the use of proprietary algorithms in criminal justice, I honestly didn't even want to give my presentation anymore. I just wanted to cede my time and to hear more from her. And, you know, I later actually learned that some of my wisest colleagues at Osgoode, including the aforementioned Professor Sonia Lawrence, were already aware of Ngozi and her work and had hoped, in fact, to convince her to come to Osgoode at some point. So Ngozi, it's really just wonderful to be able to welcome you today, kind of to Osgoode, albeit virtually, and to hear you speak again about the important issues around law and technology and epistemic violence that you're now tackling in your work. So with that, I'm going to pass things over to you, and we're going to hear from Ngozi, and then I'm going to, after we hear the keynote lecture, Professor Sonia Lawrence will be introducing our excellent panel of commentators. So the plan is that the sort of formal piece should take around about an hour or so, and then hopefully we'll have some time for discussion, and we'll see how it goes. We may finish between like 5:30 and 6 o'clock, just depending on the appetite for further conversation. So looking forward to the conversation very much, and without further ado or delay, let me pass things over to you, Professor Yokodaki.
Good afternoon. Thank you, Professor Craig, for that kind introduction and for inviting me to speak at this important conference. And I also would like to thank my commentators who will be speaking after this keynote, Professor Eaglin, Professor Tusi, and Professor Morgan. And I'd also like to thank Professor Lawrence, who's going to be moderating that discussion. And last but not least, I want to thank all the organizers for their hard work in putting this conference together. It's such an important topic, and thank you all for attending. I look forward to the conversation. I'm just going to share my PowerPoint. Okay, so my work explores the harm that predictive technologies used in criminal legal institutions enact on racially marginalized communities. And it's such a pleasure to be with you all today and to speak about my research within the broader theme of technologically facilitated violence. Algorithmic systems are increasingly informing life-altering decisions in the criminal legal system. We see their use in policing, bail, sentencing, and parole in the United States. And this algorithmic turn is also taking hold in Canada. For instance, a September 2020 report produced by researchers at Citizen Lab laid out the kinds of algorithmic systems that are being used by law enforcement authorities throughout Canada. And too often, discussions around the harms caused by algorithmic systems focus on the harms facilitated by their utilizations. Harms such as algorithmic discrimination, which concerns the fact that these technologies produce the same racial, gendered, and social inequities that their utilization was designed to reduce. And this focus is important since these technologies, through their biased predictions, threaten to entrench or worse, exacerbate existing inequities. And as the work of Wuha Benjamin and Dorothy Roberts and others show, these technologies as currently employed will serve to justify and perpetuate today's racial caste system into the future. Yet, as we think about the harms facilitated by the use of these technologies, we must simultaneously engage with how these technologies are constructed. Since the very process of algorithmic construction promotes harms like algorithmic discrimination, while also entrenching a way of knowing that is exclusionary and epistemically oppressive to subordinated and marginalized members of communities that are already experiencing intersectional discrimination and are already excluded from dominant knowledge production and validation processes in our society. So as a way to unpack these harms, my talk will focus on the knowledge sources used to construct pretrial algorithms. And in so doing, the talk will complicate the current understanding of the cause of algorithmic discrimination, its potential solutions, as well as what we really mean when we say technologically facilitated harms. And though I focus on pretrial algorithms, the problems as well as the prescription that I lay out in the talk equally applies to all predictive technologies used in the United States as well as in Canada. Before I begin my talk, it's important just to provide some context about algorithmic discrimination and the traditional explanation that's given for algorithmic discrimination. So algorithmic discrimination concerns the ways in which new technologies reproduce existing inequities, despite the fact that their uses are supposed to reduce those inequities. And the traditional explanation for algorithmic discrimination has been that algorithms reproduce racial, gendered, and socioeconomic inequities because they're constructed with biased data. However, I suggest that explanation, which I call the biased data diagnosis, is incomplete. Though biased data is an important component of algorithmic discrimination, these algorithms have a data source selection problem. Algorithms reproduce existing inequities because they are built and exclusively trained with data derived from criminal legal institutions, such as the police, pretrial service agencies, and the court system. And I call these criminal legal institutions carceral knowledge sources. And for the reasons laid out in my talk, dismantling the dominance of these carceral sources in algorithmic construction is a prerequisite for the creation of algorithms that have the possibility to produce different and potentially equitable outcomes, while also dismantling the epistemic violence experienced by these communities in algorithmic construction. So with that in mind, my talk will be divided into 5 parts. First, I'll briefly discuss the increased reliance on pretrial algorithms in the United States. Second, I will lay out the data source selection problem by exploring the carceral knowledge sources that are currently used in algorithmic construction. Next, I will detail the biased data diagnosis and how approaches emanating from this diagnosis are unable to redress the data source selection problem. I'll then sketch out a proposal for addressing the data source selection problem, which consists of dismantling the dominance of carceral knowledge sources in algorithmic construction and moving towards non carceral knowledge sources such as community knowledge. And then I'll highlight some objections that might be levied against my proposal. Each year, millions of defendants are subject to a pretrial hearing that will determine if they are released before trial. And for many, that determination will be affected by a pretrial algorithm. And this is because across the United States, jurisdictions are turning to algorithms as a popular response to the problem of racialized mass incarceration. And these technologies tend to be risk assessment algorithms that use a statistical method and information about a defendant to determine the probability that that defendant will fail to appear or will be arrested for a pretrial crime if released pending trial. And the predictions produced by these algorithms are called risk scores, and these scores are used by bail judges to determine a defendant's pretrial release eligibility. And the increased use of pretrial algorithms is part of a growing movement to use data-informed predictive technologies to address racial, gendered, and socioeconomic biases that have ushered in racialized mass incarceration. And the pretrial system is part of the story of racialized mass incarceration. Bail determinations are more often predicated on a defendant's race, gender, and socioeconomic status than on their flight risk or risk to the administration of the criminal legal system. And there is a growing movement around the need to address the racial, gendered, and social inequities of the pretrial system. And one of the objectives of employing pretrial algorithms is to fix the fact that the pretrial system incarcerates a staggering number of racially marginalized and socioeconomically disadvantaged defendants whose release would pose little to no danger to the community or the administration of the criminal legal system. And proponents of pretrial algorithms claim that the increased use of pretrial algorithms respond to this problem. They argue that the increased use of pretrial algorithms will reduce existing inequities in the pretrial system by enabling bail judges to identify and release defendants who are at a low statistical risk of committing pretrial misconduct. And their premise is that this will reduce the over-incarceration of racially marginalized and poor defendants. Despite this justification, it's important to note that the increased use of this technology is tied to a neoliberal agenda to reduce state expenditure on the criminal legal system while maintaining the deep carceral and racial logics underlying the system of incarceration itself. Yet, when we think about this question of the relationship between pretrial algorithms and redressing racial and class inequities in the pretrial system, you'll notice that that's not what actually happens. And algorithm critics have argued for a long time that increased utilization of pretrial algorithms threatens to entrench or worse, exasperate existing inequities. And these concerns have bore fruit. The greater use of pretrial algorithms has not resolved the racial, gendered, and socioeconomic inequities of the pretrial system. In fact, these algorithms tend to operate to reproduce those inequities. And this is because these algorithms tend to overestimate the riskiness of racially marginalized defendants while underestimating the riskiness of defendants that are racialized as white. They also center the idea of risk as something that can be gauged in the first place. So this leads to the algorithm disproportionately labeling racially marginalized defendants as at a high risk for pretrial misconduct. And you'll notice on the PowerPoint slide that I've included photos from the ProPublica report on this issue showing this racial inequity in risk classification and risk score assigned. So it's become clear that pretrial algorithms operate to maintain existing racial, gendered, and socioeconomic inequities in an acting jurisdiction. And the primary diagnosis for this problem, and for algorithmic discrimination generally, is that these algorithms are built and trained on racially and socioeconomically inequitable data, and therefore generate racially disparate and socioeconomically inequitable outcomes. In other words, bias in, bias out. However, this diagnosis has failed to account for the fact that these algorithms also have a data source selection problem. They are trained with data that is exclusively derived from criminal legal institutions, carceral knowledge sources. So at this point, I want to turn to this data source selection problem and discuss the kinds of data that are generated from carceral knowledge sources that are exclusively used in algorithmic construction. And by so doing, this will set us up to think about the limits of understanding algorithmic discrimination as simply a problem of biased data, and will enable us to consider the epistemic dimension of it. So developers exclusively use data derived from carceral knowledge sources. And by invoking the term carceral knowledge sources, I'm referring to knowledge sources implicated in the political and social systems that facilitate punishment, incarceration of individuals, such as police, the court system, pretrial service agencies. And in the pretrial context, developers are using data from those sources. They're using data from the police, pretrial service agencies, and the court system. And it's important to note that these sources are not just data sources, but they're knowledge sources because they produce knowledge about individuals that interact with these institutions. And that knowledge is used to drive criminal law policy and practice about public safety. And in recent years, we've seen a rise in social movements such as Black Lives Matter, which have really challenged the conception of public safety that knowledge produced by carceral knowledge sources justify. So at this point, I want to just go through the various carceral knowledge sources used in the construction of pretrial algorithms and talk about the data that they produce. So the first carceral knowledge source is the police. And the police produce two kinds of data. The first is arrest data, and the second is information produced during police stops that do not lead to an arrest. And both kinds of data consist of personal information about an individual. In the case of an arrest, that information includes the circumstances that led to the arrest, as well as the alleged crime to which the individual was charged with. The second carceral knowledge source used in algorithmic construction is data from pretrial service agencies. And these agencies are tasked by the jurisdiction to collect personal information about a defendant. And much of the information that pretrial service agencies collect are similar to the kinds of information that police officers collect. However, one important difference is that pretrial service agencies collect information about defendants' mental health history, community ties, and familial situation. And the final carceral knowledge source used in pretrial algorithmic construction is data by the court system. Courts produce two kinds of data that's important for the purposes of constructing algorithms. The first is data about convictions, and the second is data in regards to bench warrants. And all data produced by these carceral knowledge sources are input into databases and relied upon by all aspects of the criminal legal system. And developers obtain this data from these sources directly, usually in an anonymized and aggregated form. Now, there are many problems with utilizing knowledge from carceral knowledge sources. Carceral knowledge sources routinely produce inaccurate data and incomplete data. But most importantly, the data that they produce is well established to be gendered and racially and socioeconomically disparate. And this is because the criminal legal system is disproportionately concentrated on poor and racially marginalized community. So the data produced by these knowledge sources reflect these disproportionalities. And this brings us to the issue of algorithmic discrimination and the biased data diagnosis. So there's a consensus that algorithms discriminate, and that this discrimination is caused by the fact that these algorithms are constructed and trained with biased data. So bias in, bias out, a phrase that many of you might have heard. And this biased data diagnosis has spurred a number of strategies designed to combat algorithmic discrimination. And these strategies have focused on the data currently used in algorithmic systems. And I want to focus on three of those approaches to show how these approaches emanating from the biased data diagnosis are incapable of really understanding and correcting the issue of algorithmic discrimination. And the reason that approaches emanating from the biased data diagnosis are incapable of redressing algorithmic discrimination is that they don't engage in the data source selection problem. And moreover, these solutions do not touch upon the epistemic violence within algorithmic construction and the ways in which that violence facilitates algorithmic discrimination. So the first approach is what I call the better data approach. The better data approach advocates for the use of more complete and representative data sets in algorithmic construction. But to be clear, this approach is focused on getting better data from currently used knowledge sources. So again, not engaging with the data source selection problem. The second approach that emanates from the biased data diagnosis is the technical adjustment approach. So this approach advocates for technically adjusting the algorithm so as to address the fact that the algorithm was built on biased data. So one example is the colorblind approach, in which data that is heavily associated with gender, race, and other protected classes are excluded or hidden from the algorithm. Another approach is algorithmic affirmative action. And both strategies aim to counter the inequitable outcomes that these algorithms tend to produce, but again, leave in place the fact that carceral knowledge sources are the only sources being utilized for the construction of these algorithms. And the third approach that emanates from the biased data diagnosis is the auditing approach. And this approach advocates for measuring the inequitable impact that the use of an algorithm has in a jurisdiction. And the idea being that the information can empower a jurisdiction to discontinue the use or try to figure out adjustments for the fact that an algorithm is maintaining existing inequities. So though all these approaches are substantial improvements over the status quo and have the capacity to partially redress the problem of algorithmic discrimination, the problem with these strategies is that they fail to contend with the knowledge sources that are an essential component of algorithmic discrimination. And by leaving the data source selection problem intact, these approaches cannot fully contend with algorithmic discrimination. So the inability of existing approaches to correct algorithmic discrimination raises the question of what should we do? One approach would be to abolish the use of pretrial algorithms, which some scholars have suggested. Another approach would be to repurpose pretrial algorithms, which other scholars have suggested. For instance, Sandra Mason has suggested repurposing pretrial algorithms to identify the needs of pretrial defendants. And if the only data that can be used in algorithmic systems are from carceral knowledge sources, then we should either abolish or repurpose pretrial algorithms. But data from carceral knowledge sources is not the only data out there. There is data from non-carceral knowledge sources. And if we want to address algorithmic discrimination, we need to shift away from carceral knowledge sources and tap into non-carceral knowledge sources. So in the paper that this talk is based off, I explore data produced and validated by communities most impacted by the criminal legal system, which I call community knowledge sources, as a potential non-carceral knowledge source worth utilizing in algorithmic construction. And data from community knowledge sources have traditionally been excluded and discredited in algorithmic construction. And one reason that's often given for this exclusion is that community knowledge sources produce qualitative data. So the argument is that because community knowledge sources produce qualitative data, they can't be used in algorithmic construction. But there's a lot of problems with this justification. First, algorithmic construction involves quantitative data as well as qualitative data. Developers utilize qualitative data when they informally or formally collect that data from institutional actors in the algorithmic construction process. Moreover, community knowledge sources produce quantitative data as well as qualitative data. So that whole distinction is not the reason we're seeing the non-use of community knowledge sources. The real reason that we don't see data from community knowledge sources being utilized is because of epistemic oppression. Dominant knowledge production and validation processes discount knowledge produced by subordinated communities, such as communities most impacted by the criminal legal system. So the data produced by these communities has been discredited and deemed not credible for algorithmic construction. And this discrediting of community knowledge stems from the racial, gendered, and class dynamics in our society that have disabled those from subordinated groups from equally contributing to knowledge production. Moreover, this discrediting serves racial ends and facilitates the creation of algorithms that are destined to reproduce the racial, gendered, and class hierarchy that we have in the criminal legal system and beyond in society today. So my proposal is that we dismantle the dominance of carceral knowledge sources in algorithmic construction and shift to non-carceral knowledge sources. And one category of non-carceral knowledge sources that warrants attention is community knowledge sources. And one example of the kind of data produced by community knowledge sources concerns the qualitative data that community knowledge sources collect from formerly and currently incarcerated people hailing from most impacted communities. And community groups representing most impacted communities have really been at the center of the collection and dissemination of this kind of qualitative data. And some of those organizations in the United States are National Council for Incarcerated and Formerly Incarcerated Women and Girls, as well as Safe and Just Michigan. And the qualitative data produced by formerly incarcerated and currently incarcerated people has been critical in unearthing the harms of the current system of pretrial incarceration and can really enable a reckoning around the ways that the current pretrial system pursues a conceptualization of public safety that's not true public safety and fails to protect the safety of defendants, their families, and their communities. And to think about some of the benefits of shifting to community knowledge sources, we should really think about the fact that doing so could really facilitate a reconceptualization of public safety, a conceptualization of public safety that actually promotes true safety in that it would be inclusive of defendants, their families, and the communities they come from, but also one that could provide a realistic assessment of what's at stake when it comes to pretrial incarceration. And this could facilitate an anti-racist conceptualization of public safety. Another benefit is that shifting to community knowledge sources could enable us to really think about harm reduction and could provide an understanding of public safety that reduces the use of pretrial incarceration, particularly in areas that are already heavily harmed by the criminal legal system. And there are a few ways we could imagine tapping into community knowledge sources. We could utilize community groups on the ground. We could also create new institutional structures and arrangements designed around facilitating this knowledge. At the same time, there are objections to my proposal, and I'm happy to talk about them in more detail in the discussion portion of this panel, but I'd like to preview two of those objections now. So the first objection I'm going to preview is the accuracy objection. And the accuracy objection is that algorithms that are built on data from community knowledge sources will be less accurate than algorithms built on data from carceral knowledge sources. And the response to this objection is that we really need to rethink what we need by accuracy. What do we actually mean when we say we want an accurate algorithm? Accuracy has to be understood within the context of what we want from the pretrial system, what we want the pretrial system to do, and how we understand public safety. Given this, using data from community knowledge sources might make algorithms more accurate because it could enable the construction of an algorithm that produces assessments that realistically account for the harms and benefits of pretrial incarceration, while at the same time providing a vision of public safety that can be inclusive to everyone in society, even the most marginalized people in society. The second objection that could be levied against my proposal is the democratizing objection. And the democratization objection concerns the fear that data derived from community knowledge sources will not be less biased and may in fact be more biased. And if relied upon, using community knowledge sources could usher in a more punitive system. And it's true that shifting to non-carceral knowledge sources, such as community knowledge sources, doesn't guarantee a specific outcome. And shifting to community knowledge sources alone may not even provide a complete solution to algorithmic discrimination. However, it is only through dismantling the dominance of carceral knowledge sources that we could begin to think our way through algorithmic discrimination and its redress. Moreover, it is through doing that that we could really begin to unlock the ways in which our society oppresses most impacted communities in a way that is epistemic. And so through engaging with community knowledge sources, we can start to dismantle epistemic oppression by actually engaging with the knowledge of these communities, which could facilitate disrupting the ways in which the pretrial system facilitates racial hierarchy. Moreover, there's reason for optimism around community knowledge sources, especially when we think about social movements that are currently underway, as well as community groups that are at the center of the collection of community knowledge. Given that, and given the potential of engaging with this knowledge, while at the same time recognizing the racist and classist quality of the data produced by carceral knowledge sources, it's worth making this shift. In conclusion, there's agreement that the harm of algorithmic discrimination threatens the ability of algorithmic systems to redress current inequities. If we're serious about addressing the violence that is algorithmic discrimination, then we have to look beyond the biases in the data that we currently use to build these algorithmic systems, and instead contend with the knowledge sources at the heart of algorithmic construction. Correcting algorithmic discrimination may be possible, but its redress requires a paradigmatic shift away from carceral knowledge sources. Perhaps pretrial algorithms and other criminal legal technologies could offer a path to radically reorienting the criminal legal system in a way that would reduce the harms that the system currently enacts on racially marginalized people. But unlocking that potential requires dismantling the knowledge sources that brought us here in the first place. Thank you.
Thank you so much, Ngozi, for that really important and interesting intervention that is less about kind of not or trying to avoid algorithms altogether and more about thinking about where the data comes from. I think that's a really important place for us to be directing our attention. So let me introduce the three commentators. Professor Eaglin, Professor Morgan, and Professor Tusi. Professor Eaglin is an associate prof at Indiana's Moore School of Law. After clerking and practicing, she specializes now in criminal law evidence and US federal sentencing law. In a recent paper, she argued that we need to pay more attention to how new technologies in use in the area of sentencing are changing our understandings of punishment. And her recent work, When Critical Race Theory Enters the Law and Tech Frame, is available on SSRN, and I'm sure will be of interest to a lot of people who are here today. Next, Professor Jamelia Morgan is Associate Prof and Robert D. Glass Scholar at UConn School of Law, where her work focuses on disability as a legal category in US law and its intersection with policing and criminalization. Prior to joining UConn, Prof. Morgan was a litigator with the Abolitionist Law Center, and she worked with the ACLU National Prison Project. Her paper, Rethinking Disorderly Conduct, won the 2020 Junior Scholar Paper competition of the AALS Criminal Justice section. And finally, we will hear from Professor India Tusi, Associate Prof at the Delaware Law School, where she works on policing race and gender. After law school, Professor Tusi clerked and then worked for the South African Department of Human Settlements, the ACLU, and the Opportunity Project. Her 2020 paper on beauty and policing combines anthropological methods with legal analysis about the policing of sex workers in South Africa. You can also read her review of Aya Gruber's critique of carceral feminism in the Harvard Law Review. And finally, her book, Policing Sex, is forthcoming from Stanford University Press. So all three of these scholars bring together on-the-ground litigation experience with critical theoretical orientations, using critical race theory and critical approaches to feminism And like Professor Okedebe, the work of Professor Eaglin, Morgan, and Tusi warns us that in thinking about technology-facilitated violence, or TFV, we have to think not just about interpersonal violence, but about state-generated technology-facilitated violence. So to the extent that feminist law reform has generally focused on the state as a potential ally of this work, I think these interventions are critically important if we hope to engage in truly intersectional feminist approaches in our thinking about TFV. We have to take seriously how women from Black, Indigenous, low-income, and other racialized or medicalized communities are facing the kind of tech-facilitated violence emanating from the state that's described so ably by Professor Okedebe in her discussion of state and proprietary algorithms. These affect women in very broad and growing swaths of their lives. So with that introduction, let me turn first to Professor Eaglin for her comments on Professor Okedebe's paper.
Thank you. Thank you for that kind introduction and the opportunity to join all of you today. And thank you to Professor Okedebe for the wonderful comments on her excellent paper. So I am going to focus my comments on three things. I'm going to start by spending a little bit of time locating Professor Okedebe's work in conjunction with the field, but also specifically with some of my own research in the same area. And then I'm going to talk about the significance of this contribution. And then I want to finish up by just raising a few questions or comments that we can think about specifically about the paper to facilitate conversation going forward. The first thing I want to talk about actually was sort of previewed in some ways by Professor Lawrence, which is this interesting dilemma of, I think, scholars grappling with the issue of the expansion of algorithmic systems in criminal administration. There's this significant pull to that one that I think Professor Okedebe recognizes in her article. There's this enthusiasm to fix it. Yes, these tools are problematic. There's lots of ways to sort of frame what's wrong with them, and this frame of algorithmic discrimination is quite dominant. And is growing sort of in its traction from things like the ProPublica report that Professor Okedebe referenced in her PowerPoint. On the other hand, there's a lot of, and there's a strong sort of impetus to just get rid of the tools. Get rid of the algorithms. They are a source of, if they are part of the problem, or if they're not part of the solution, then they're definitely part of the problem. And I have written both because it is my strong conviction that it is not enough to call for the abolition of this technology. That's not on its own going to solve the problem, because we need to understand why we want this technology so much. And to that end, in 2017, I wrote an article that I felt very dissatisfied with, that basically said, here's how the algorithms are made, and here are all the problems with the way these algorithms are made. And at the very least, the thing that nobody seems to be talking about are the ways that people, the demos, basically marginalized people in particular, who are most affected by these tools, are excluded from the decision-making process in whether to adopt them and why to adopt them and to what end they would be used. And I think that I see, and I'm so grateful because Professor Okedebe's work has picked up on that strand and ran with it in ways that I couldn't even dream of. And I see this project as yet another contribution that tells me that my article was not good enough. And I am grateful to have the opportunity to comment on it and to see it being published. So, I think that she is, I think she and I may be one of very few critics of actuarial risk assessments that persist in playing in the space of not just whether to adopt them, but what they should look like and what it means that they look in certain ways and how that reflects our own views about knowledge and what kind of knowledge matters and why it matters and what it means. So, and I think this project very much builds on that. So in Discredited Data, Professor Yokodaki successfully reveals an obscured aspect of this emerging algorithmic discrimination frame, which is that we are exclusively relying on carceral knowledge sources, as she suggests. This is, and I think in the context of this convening, this is such an important contribution to the field because it illuminates the way that these technologies, actuarial risk assessments, are bringing epistemic violence in numerous ways that I think go unacknowledged in the literature. So I just want to highlight a few of the ways that her project is bringing that forward. So of course, there's the violence that it brings, and I see the project as highlighting the violence of sort of institutionalizing the perception that some kinds of knowledge are not valuable, right? Discredited, the knowledge of communities who are most affected by the carceral state. But it's not just that. And there's this point, I think it's on page 20 of her paper, where she highlights that one of the implications of adopting actuarial risk assessments is that it's actually affecting judges and the way that they think in pretrial determinations. And that it is actually obscuring, or excuse me, it's also discrediting and devaluing the other kind of knowledge sources that they would draw upon if there were no actuarial risk assessments in their decision-making profile. And I think that this is something that I write about, and I just recently wrote about, actually also in the Cornell Law Review, in the context of post-conviction sentencing, which is this issue that we think that that judges are the basis of the problem. And if judges are biased, then the actuarial risk assessments, in fact, can't be worse, right? And I think that this article is building on that framework of saying, no, we're creating new kinds of knowledge. And if we don't understand this as creating knowledge, then we will miss the ways that we are actually devaluing many other types of knowledge, not just from institutional actors like judges, but also not just by people who are most affected by the carceral state, marginalized communities, right? And so I think that that's a really important sort of aspect of this violence that gets obscured because people presume, don't judges already think about risk? Well, not really. Maybe they do, maybe they don't. But when we institutionalize these kinds of tools, we are telling them that there are some kinds of knowledge that matter more. And then the other aspect of violence that I see her project is highlighting is the violence of legal discourse, right? And the idea that algorithmic discrimination does work in and of itself. When we talk about algorithmic discrimination, we are then forced into this conversation about which kinds of carceral knowledge are the right kinds of carceral knowledge, which kinds of, what kind of factors, can we take race into account to discount for the fact that the actual risk assessments are already deeply problematic. But this limits our ability to conceptualize what is wrong with the carceral state. And I see this project as writing into that space and saying that this technology is doing work that is trying to tell us what is wrong with the carceral state, and the work of critiquing it through the frame of algorithmic discrimination is doing the same. And if we see them as working together in sort of shaping our understanding of this present, then it is even more important to see that actuarial risk assessments are not inevitable. They are not, they're not just a reflection of reality. They are instead a production of reality. And I see this project as very much writing into that space and trying to illuminate this aspect that I have seen as well. But I think that few people really try to pick apart in the way that I've seen Professor Yokodaki do, which is to say that if they are constructed, if they are truly constructed, then we really need to think about what it means to deconstruct them, to build a new vision of of society, a new way of understanding. All right, so such great contributions, very important. I now want to just transition, how many more minutes? I think I have a few more minutes. So I want to transition and raise a couple of questions or comments to think about going forward. So to begin with, I want to set up a hypothetical. Let's say I totally agree with I do agree with your project, but let's imagine that I agree with your project, but I really like actuarial risk assessments. And I think that, you're right. There are these problems with carceral knowledge. So why don't we just use zip codes? And why don't we just use, I don't know, mandated school reporting? How many times has an individual been excluded from public school or some other school, and use that as a predictor for recidivism, instead of using these complicated and problematic arrest records and carceral or convictions and other forms of carceral knowledge that you identified? Isn't that going to solve our problem? It's not carceral knowledge, right? But then it also isn't getting to this other point that you raised, which is, why don't we use the data or why don't we try to create basically data from the most affected individuals by the carceral state? So I'd love to hear you talk through that, because I think that illuminates a couple of areas in your part 3 in particular that I think could use a little bit of revising. And then the other question I had is, okay, great. So let's use this information from these sort of prison anti or abolitionist organizations. What does that look like? What do we do? Do we go in there and we take their podcasts and we call their podcasts for hard data? Does it look like, as you suggest in the paper, that we just say, instead of, as actuarial risk assessments do right now, saying that having a child is a factor that makes you high risk, we make that something that makes you low risk? Does that actually change the broader framework? Or is the point, okay, I have 1 or 2 more minutes. Okay, so, or is the process the point? Right? In which case, does it really matter if we change the actuarial risk assessments at all? Do you actually care about that? Or is the point that we should just be talking to the most affected individuals from the expansion of the carceral state? And what is the value? What is the work that happens when we embed that into the actuarial risk assessment design process? And how can we understand that as being different from the larger democratization literature, which suggests that when we think about how to address mass incarceration, we should be starting from the bottom, right? And looking at those individuals who may not want to play in the world of technology in the first place. So how can we understand this project as actually being sort of pro actuarial risk assessments, even if it's anti sort of discredited data, or it's pro discredited data, instead of just being full on actuarial risk assessment abolitionists, right? Because if we start with having a conversation, and as you've written about in other projects, if we start by having a conversation with these individuals, why would we constrain them to fixing a tool? All right, I have many more things that I could say, but I will cede the floor and I look forward to the conversation.
Thank you so much, Professor Eaglin. That was very interesting. And Professor Yokodaki will give you a chance later on to respond. For now, we'll turn to Professor Morgan.
Good afternoon, everyone. It's really a delight to be here and to just hear from so many of my fellow Black women colleagues in the legal field. I read your work, I know your work. I'm just really proud to be in conversation, and in particular to celebrate our scholar here of the hour, Professor Ngozi Yokodaki. I want to talk a little bit, Ngozi, about Professor Yokodaki. I want to talk a little bit about some of the key questions and ideas and directions that your awesome paper sparked for me. I highly encourage everyone to take a look at the draft when it's available, because there's so much incredible fodder for future research on this topic. I think you do an excellent job, as Professor Eaglin laid out, in sort of grounding your contribution to this field. And I think in many ways, you are challenging those that have been writing in this space to think about race and the production of racialized knowledge and racial subordination through the law and tech lens, specifically algorithmic construction. I want to ground my remarks in I believe your part 3, looking at subjugated knowledge and thinking about abolitionist epistemologies. As you know, there are questions of power that are intrinsic to both of those lenses. So I want to quote a little bit from what you've written, think about some of the ongoing theorizing around the abolitionist epistemologies, of course, building on Foucault's subjugated knowledge framework, and then pose a few questions for you again to hopefully offer some fruitful discussion for the remainder of our time. So you note in the paper, and I think you capture the definition, implications of subjugated knowledge very clearly and helpfully. So I'm going to read a passage. So you note that the exclusion of community knowledge sources cannot be justified as a mere preference for quantitative data and algorithmic construction. A more fitting explanation for this exclusion is that the knowledge produced by community knowledge sources is a type of subjugated knowledge. Subjugated knowledge refers to knowledge that is suppressed and largely unacknowledged outside of the epistemic community that created and validated it. In his lectures in the Archaeology of Knowledge, Michel Foucault explained that the subjugated status of this knowledge is not coincidental and instead is rooted in power. Because of the disempowered status of holders of this knowledge is buried and masked by more dominant forms of knowledge. Most impacted communities are but one disempowered group that experience the subjugation of their knowledge. I think the paragraph not only captured at least my experiences in the criminal legal system as an advocate in particular, and the experiences of my client, but this complex dynamic of thinking about what you term discredited data, but also situate in this greater, larger context of producing particular types of knowledge from that data and distinguishing out dominant forms of knowing versus subjugated forms of knowing. I think you do a good job of centering in the harms, building on Professor Miranda Fricker's work. You note one harm is that members of these communities are unable to participate in the crafting of law, policy, and practice. So this exclusion from democratic processes very much links your work to the ongoing debates, which you note to and allude to, or expressly identify in part 4 about the democratization of criminal justice processes, the efficacy, the utility, the purposes of that, and distinguish your project from those important conversations. Another harm that you note, harm stemming from subjugation, is that this type of subjugation ensures that powerful groups have some sort of unfair advantage in structuring our understandings of the social world. And we can think about this as in many ways centered in debates between defund movements and abolitionist movements. What do we really mean by defund? Advocates rooted in abolition theory and organizing would say it's more than just tweaking with budget lines, but the dominant ways of doing criminal justice reform sort of gravitate towards the status quo. And we saw that in the co-optation of that platform by mainstream liberal nonprofit organizations and leaders. So I think you capture the harms really concretely, and I think situate the project in some of the ongoing challenges and potential hopeful directions that we can take this transformative change moment. So I want to kind of think about the question of discredited data, building on your invitation and your analysis. through the lens of race, gender, and disability. I think in so many ways, your work, along with Ruha Benjamin and Dorothy Roberts, Jessica Eaglin, have really helped me think about race as a technology and the meanings that are embedded into technological risk assessments, even though there's sort of this frame, as all of you know, that technologies are new and different. They can be pretty much reinscribing the same old ways of doing things. They're in many ways ascribed with and imbued with particular social meanings. We think about race, this is certainly true, that have had predictive purposes. I mean, historically, race functioned to predict criminal propensities, the risk of disorder, the risk of social harm, and in many ways that the entire technology of race is a way for dominant cultures and groups to identify individuals for segregation, policing, convict leasing, chattel slavery. I mean, think about the systems of oppression and the ways in which race is inscribed into bodies to determine social ordering. In many ways, Professor Tusi, your work has helped me think about and broaden my gender analysis and thinking about the policing, in particular of sex workers, and in thinking about that in a longer history. So when you bring in the gender and disability lens, for instance, you can think about the policing of quote unquote promiscuous women in the eugenics period. They were labeled as feeble-minded and also risky for the defective trait of wanting to express oneself outside of traditional dominant norms. And they were labeled as feeble-minded, segregated in institutions, and forcibly sterilized. In our constitutional jurisprudence, the case of Buck versus Bell, we see the Supreme Court sanctioning the forcible sterilization of then 17-year-old Carrie Buck, a white woman who was labeled as being feeble-minded. So again, the use of both gender and disability in the labeling and identification of disability was type of a risk code. Why was it risky? Because those individuals were labeled as posing a risk to the dominant white race, right? Polluting the race, corrupting the genes, of the white racial group, and hence a whole program of eugenics was around identifying harmful predictive qualities, termed defective traits, labeled feeble-minded, and removing them physically from society or removing their ability to reproduce. So again, like the race, gender, disability, and risk, and thinking about it in the greater context of discredited data is again a direction that your work took me in. What we know about risk is in many ways, as your work shows, what carceral institutions and their carceral data tell us we know about risk, right? So risk scores are used by bail judges, as you note, as a factor in determining one's eligibility for pretrial release. I know we've spoken about this on a number of occasions, but your arguments can be expanded to so many different areas of the criminal legal system. So in reading your particular discussion about risk, I'm thinking also about Dorothy Roberts' work on order maintenance policing, and in many ways, the use of sort of informal assessments as to risk, not risk scores, but police determination as to who was a disorderly person, sort of identified police heuristics as to who was risky, who was prone to be engaging in conduct that would be disruptive to the public peace. And so again, in her work, you see a bifurcation between orderly and disorderly that again tracks racialized lines, tracks gender. And in my current project on rethinking disorderly conduct, which Professor Lawrence alluded to, I also in particular focus on disorderly conduct laws as providing police with broad discretion to make their own risk assessments, to remove individuals from public places, unsheltered communities, disabled people, individuals labeled as engaging in sex work, to remove them from public places because, again, the label of risk is sort of used to make a set of predictions as to one's or a group's propensity to engage in disorder, to commit criminal acts. So expanding it to the policing context, I think, is another frame that might be helpful. So in your paper, Beyond Prediction, you also talk about credibility. So here again, I think this is an important, again, thinking about sort of discredited data and its connections to the extensive literature on credibility. You note that through unpacking the data source selection problem, your article offers an explanation for why certain knowledge is normatively understood to be data that is credible for use in algorithmic systems, while other knowledge is not. So as you know, Bennett Caper's work has evaluated this dynamic, sort of this, credibility assessment or lack of credibility that's imputed onto Black people who are routinely disbelieved in the criminal legal system as witnesses, complainants, and defendants. To think again about the disability lens, the passage reminded me of Jasmine Harris's work looking at sexual consent and disability, and thinking about Harris's discussions and in particular discussion of the research that identifies that jurors are likely to perceive witnesses with intellectual disabilities to be fundamentally honest, but also at the same time, they ascribe a set of negative attitudes towards their capabilities as witnesses. So again, thinking about data creation in the witness, on the witness stand and in court processes and their intersections with credibility, identity, and status is another direction that I think your work points to. So a few questions to consider. So one, how do we construct the we? And I know so many of us are thinking about this as we talk about the community and criminal law reform and beyond that, transformative change. How do we construct the we and not reproduce marginalization and hierarchy? In your paper, you talk about a few of the awesome organizations doing abolitionist organizing, or at least pushing for transformative change. Are there insights that we can draw from their governance structure, how they set policies and proposals that, again, construct the we so that we can develop a set of, as you said, it's not even developing because they're already existing qualitative data sources that are out there and available for the taking? How do we manage, and this is something that I think about quite a bit, but how do we manage social and physical disorder without calling the cops or resorting to punitive corporate surveillance through, the Ring app, Nextdoor apps, et cetera? So this broader conversation about information that communities have on how to not only keep their community safe, but how to keep them orderly, how to keep public spaces accessible in ways that don't, again, rely on our punitive surveillance state. You propose community knowledge sources that certain sources contain the knowledge produced and validated by the communities most harmed. I think that's right, that's consistent with Black feminist praxis and organizing, but how do we assess harm? How do we determine who are the most harmed? So in a way, I think, as you've done in your prior work, another plug, the democratizing potential of algorithms, ? I think is a really interesting way of, again, identifying a problem, but also operationalizing it. And so wanting you to maybe speak to the audience about your prior work on thoughts on operationalizing some of your proposals. And so lastly, in the last minute, I want to, again, invite you to opine on this question of abolitionist epistemologies. I think the recent book by Professor Liat Ben-Moshe, it's a terrific book called Decarcerating Disability, again, captures, I think, so much of the methodology that you're engaging in. So it's a type of resistance to hegemonic forms of knowledge, and you're identifying a set of assumptions that have yet to be challenged, which is why I think the work is so important. So I wanted to get your views on what a kind of abolitionist epistemology could look like in this context, if it's pre-trial, if it's this broader law and tech world. And I want to end with a quote from Professor Ben-Moshe. So, as subjugated knowledge, one can view abolition as a specific epistemology, one that is counter-hegemonic, that is opposing the status quo and taken for granted assumptions. The hegemonic discourse is about the need to segregate others in the name of safety from themselves or the people who might encounter them, in the name of punishment and as a form of justice and rehabilitation. Abolition counters these discursive frames with the kind of vision it encourages of a world in which carceral and segregated locales are viewed as senseless and common senseless. Abolition is not merely about closure of prisons or institutions, it is a revolutionary framework that transforms the ways we analyze and understand forces that shape our histories and everyday lives. Abolitionist knowledge reconceptualizes notions like crime and innocence, what gets to be defined as crime, who gets defined as criminal, disability or madness as an identity, and politics, not only a medical diagnosis, and rehabilitation, which is seen as a form of assimilation and normalization, not just as benign treatment. Ideas of punishment, whether it's transformative justice, revenge, or retribution, notions of freedom and equality, whether we can feel free and safe without locking others away. And on the other hand, concepts of danger and protection. Whom do we protect by segregating people behind bars, in psychiatric hospitals and prisons? I think your work is really inviting us to dive deep and really contest some of these categories. So I just thank you for sharing with us, and I look forward to the discussion.
Thank you so much, Professor Morgan. I'll try to put some of those sites in the chat for those who are interested, and we'll turn to Professor Tusi.
Thank you. Thank you for the invitation this evening. And thank you, Professor Yokodaki, for allowing us to engage with your work and sharing this piece with us. And it's an interesting conversation, just hearing everyone else's feedback and thoughts in terms of how it interacts with their own work. I remember back in like 2014, 2015, when there was so much excitement around these risk assessments tools. It was around the time when people there were these different coalitions around mass incarceration or over-criminalization, depending on how you speak to. And people thought, maybe one way of dealing with this problem is these objective risk assessment tools. But even back then, Professor Eaglin was one of the first legal scholars who was actually observing and critiquing, the limitations of these risk assessment tools. And as Professor Morgan's work illustrates, even how we assign risk and who's risky, right, is built into these notions around ableism and patriarchy, racism, right, how we assign these different behaviors, yet we expect these tools to do this in some sort of objective way. Now, both Professor Eaglin and Morgan spoke a bit about, how do we address the issues? What are the potentials, for algorithms? Are there any potential? Should we just focus on more of an abolitionist framework? I'm going to actually focus a little bit more on like the sourcing problem, and I'm going to really be focused on police and getting a little bit, I guess, into the weeds a bit, and bringing in some of the insights from my own research. And so Professor Yokodaki notes that algorithms have a sourcing problem, and as she puts it in the paper, quote, "They are built on and trained exclusively with data derived from criminal legal institutions such as the police, pretrial services, and the court system." And she refers to these institutions as carceral knowledge sources. Now, the way I see it is these sources are problematic because the technologies fail to account for the ways that the state itself is a source of violence. Now, this failure allows state violence to be pretty much baked into the algorithms, which facilitates technologically facilitated state violence. Now, I'm going to spend my time discussing the carceral knowledge source of the police. Now, today is George Floyd's, the anniversary of his death. And, we're in this moment, at least, where there's a collective consciousness about the shortcomings of policing. Many people understand that we have a problem with policing in Canada and the United States, around the world. Perspectives on the nature of the problem vary depending on whom you speak with, but there is an awareness that, police violence exists. And oftentimes, Black people, Indigenous people, Latinx people, people of color are often the recipients of the most violent forms of policing. Now, there are many studies, right? We know there's research that backs up the fact that we have a problem with police violence. There are many studies that demonstrate that there's rampant racial profiling. Black communities are policed aggressively. Black motorists are more likely to be pulled over and ticketed. Black people are more likely to be stopped and frisked, even when they're less likely to carry contraband than white people. And Black people are more likely to be killed by the police. These data are from old studies, some of them from new studies. There's been consistency in terms of illustrating and demonstrating and proving that there's racial bias in policing. And we have a profound problem with policing to the extent that one views racial bias as a problem. Some researchers have hypothesized that is because of blue wall silence. Others, it's implicit bias. Others, because there's a lack of democratic control of the police. Now, Professor Yokodaki outlined the data source collection problem in her talk and in her paper with pretrial algorithms. And one of these sources is the police organization, even though we know all this information about the shortcomings of police. Now, I'm going to discuss some of the issues with looking to the police as a source of knowledge by drawing from my own research. Of late, I've been concerned with how to evaluate policing when we consider it within its relevant social and political context. I have a forthcoming paper that argues that policing is not a public good when situated within its relevant social and political context. And in that paper, I propose a methodology for evaluating policing. I set out several questions for examining the qualities of policing. And some of those questions include, who are the dominant groups in this community? Whose interests are currently being protected by the police? How prevalent are incidents of violence by the police against community members? Whose property do the police currently protect? Who has the most interactions with the police? Who feels protected by the police? Who does not feel protected by the police? Now, the responses to these questions often reveal the ways that policing reinforces the social hierarchy in a given community, and it's not just a mere social good that's provided for everyone's protection. Let's take Chicago, for example. Chicago is the city with the highest per capita policing spending in the United States, yet it has a history of police torture, police corruption, police incompetence, and still has a relatively high crime rate, although they have the highest per capita spending on policing. That highest per capita spending on policing has not rectified the crime situation there. Yet oftentimes progressives and even liberals and conservatives have suggested at different times that the cure to Chicago's crime problem is more policing. Now, this is problematic when you situate Chicago police within its relevant social, political, and economic context. Oftentimes, substantial police resources has facilitated substantial police violence. So policing appears to often be a problem rather than a cure. But we go to police for our data. And the police data that is incorporated into pretrial algorithms is supposed to tell us something meaningful about whom is risky. However, the bias of policing is baked into that data and creates this sourcing problem that was discussed earlier. And I like to further crystallize why this is a problem. For example, police officers profile women based on their perceptions of where they fit into the social hierarchy. So in my past work, I considered the ways that policing has actively engaged in the maintenance of racist and sexist social hierarchies. My piece on beauty and policing examines how police perceptions of beauty that prioritize white skin and European standards of beauty impacted how police officers policed sex workers. Likewise, in Washington, D.C., New Orleans, and New York, there have been a number of studies that show that police are likely to profile transgender women as sex workers or penalize them for merely carrying condoms with them. But according to police data, a Black trans woman who has been profiled as a sex worker and arrested is riskier than a middle-class woman who has not been profiled by the police. Another example, numerous studies have illustrated the ways that Indigenous people encounter discriminatory policing. Now, these algorithms facilitate a situation where a low-income Indigenous teenager who has experienced multiple stop and frisk and whose personal information is recorded by police officers during these stops can be calculated as riskier than a rich white teenager who regularly uses cocaine but has never been subjected to racial profiling or any sort of police intervention. Now, incorporating police data in these cases allows discriminatory police practices to be the foundation for assessing whether someone is entitled to freedom pre-trial. They allow discriminatory practices that are racist, sexist, ableist to facilitate technological violence and intersectional marginalization. Now, although the police are supposed to be reliable sources of unbiased data, police data is biased. We know this. We have a good empirical record of this. And including these data as sources of reliable information about people reflects the biases of an institution with a history of racially and sexually based violence. Now, the algorithms both reproduce and preserve in opaque computer codes the outcomes of discriminatory policing practices that harm the most marginalized communities, the same communities most likely to experience police violence. Police data memorialize police violence. So relying upon these data for algorithms facilitates technological violence. So as a result, it's not really surprising that the data are racially skewed and biased. They're the products of a social enterprise that's been concerned with maintaining social hierarchies, including white supremacy. So the use of police data presents a sourcing problem, as Professor Yokodaki has illustrated. Now, I've spoken about some of the problems with including the data, but some of the sources that have been excluded are also problematic, and Professor Yokodaki describes them as being discredited or not given the full consideration that they are due. Now, I like to also point out that there's a problem with the sources that are credited. So on this anniversary of George Floyd's death, given the biases I've discussed, I question whether algorithms should even treat police data as credible, or do we have enough research about the police to argue that police organizations are sources that should be discredited, right? So I'd be curious in hearing Professor Yokodaki's thoughts on that. Like, should we discredit the police, given some of these problems that we know about policing and the ways that the data is collected? And I also have a few additional questions for Professor Yokodaki. So, how do we overcome this sourcing problem when much of what I've said, and Professor Eaglin mentioned this, as well as Professor Morgan, much of what I've said can be said about all parts of the criminal legal system? Like, how do we get past that problem? Do these biased data still have a role to play in the administration of criminal law? And more fundamentally, is there a way to fairly assess risky, like who's risky, what's risky in a white supremacist country? Aren't empowered outsiders or empowered people who are in out groups always risky to a certain extent to the preservation of a dominant social hierarchy? Or another way of putting it, as activists or advocates often say, is the system just working as it should and the technology is just preserving the hierarchy as intended? Thank you.
Thank you so much, Professor Tusi. I didn't even get to give you the time warning because I was listening a bit too intently. So now I'm going to turn it back to Professor Yokodaki to see whether you want to respond a bit to some of these comments. And then maybe we can open up a conversation between the panelists.
Thank you so much. Thank you so much, Professor Eaglin, Professor Morgan, and Professor Tusi for serving as commentators on this piece. I love all of your work, and it's been so influential to me in thinking about these issues, and these comments are great, and I really, truly appreciate them. I won't be able to deal with all of them because I do want to give time for questions and answers, but I want to deal with a lot of the really important threads that were raised. So to start with, Professor Eaglin, as you know, your work has been so influential to mine. You really started this process of, and as Professor Tusi said, just thinking about just critiquing the notion that risk assessments were going to save us, that they were going to essentially be able to dismantle the racial and socioeconomic inequities of the system because of the fact that they were deeply embedded in these carceral racial logics. And so, and something that you really highlighted is thinking about when you, in your first piece, thinking about this question of, having the people most impacted by these technologies having to say, what does that mean, right? And in thinking about that, there has been, as you know, processes developed, such as in Pennsylvania, that have given communities a say, which essentially just give them a say, but no power to actually determine whether or not they want to use these algorithms, whether they can just fundamentally reject the algorithm project, and what that algorithm would look like. And so your work has been just so fundamental in helping me think about this, and it's helped me think about this thread. And so to go to your first point, which is stopping at carceral knowledge sources, I think this is so fundamental. One thing I have been thinking a lot since writing this draft of the piece and in my rewriting I've been really thinking about is, can we really understand carceral knowledge sources as merely just criminal legal institutions? Maybe we need a broader understanding of carceality that takes into it takes into account the ways in which we're talking about systems that control and manage marginalized people, and also take into account other systems of power. So when we think about zip codes, as you're talking about, we're talking about racial segregation, right? We're talking about systems that are designed with in mind to control and marginalize these communities. So using that kind of data, though it doesn't come, as you said, from criminal legal institutions, doesn't get us to anywhere of a better place. We know already, actually, and there's been a lot of really great work outside the criminal legal context as well, that, using these, these elements, and actually you yourself in constructing recidivist risk talked about zip codes actually as being, a fundamental problem in thinking about sentencing. Sorry?
I set you up.
And this just shows you, as I said before, Professor Eklund's work has been so influential. I know every line. But seriously though, as Professor Eklund has said in her work, that using zip codes in the context of sentencing algorithms is one reason we see these algorithms ascribing high risk scores to racially marginalized people. So one thing I have been thinking about is thinking about this question as more of a spectrum as opposed to just non-carceral knowledge sources and carceral knowledge sources, and also just rethinking carceral knowledge sources just being in criminal legal institutions. And your comments just have let me know that I should do that, and that's the right path. The other thing I think is really important in this work is I kind of see this paper as kind of a follow-up to my other work, which Professor Morgan mentioned, democratizing potential of algorithms. And what's really critical, I think, is that we shouldn't force communities to fix a tool, right? We shouldn't force communities to engage in a certain kind of logic. And so one thing that underlines this question of even engaging with this new epistemology that communities have already been imagining around what safety looks like is choice. The ability to just reject it. So I see my project as more thinking about if communities want to engage in the space of having algorithms, what is a really fundamental barrier to thinking about these algorithms as anything more than supporting racial hierarchy, supporting the notion of Black criminality, and many of the notions that you've talked about in your previous work, Professor Eklund. And so that's kind of the starting point. But even in thinking about that starting point of whether algorithmic construction, whether algorithms can support abolitionist projects, I think is a really hard question. And this gets to Professor Van Sutherland's written about this as well. And I struggle with this, but I think it's important to think through this idea of whether it's possible for communities to engage in algorithmic construction from an agonistic posture and to reject some of the notions around these algorithms around risk and the idea of individuals having certain traits that make them risky, as opposed to, as you've argued, Professor Eklund, that risk is actually socially constructed, right? We know that when we're talking about risk, we're really talking about the state refusing in its duty to provide resources for marginalized communities. And so in thinking about this question of whether algorithms could be an abolitionist project, I think it's important to understand the limitations. Maybe it can't, right? And I think that, my paper tries to push this idea of thinking through this question of if we really engage with this data, what would it really mean? And actually in a good faith way, not in a way of just allowing communities to, be as you have noted, to just be told, here's what the algorithm has to do, right? But if we actually engage with what the visions of reform that communities have on the ground, what could that look like? And I think that could be quite powerful. I think that it could go beyond just changing the algorithm. It could go towards changing the pretrial system. It could be a way of dismantling the system from within and reconstituting it. But again, we don't know if that could actually happen. And that's something that I have to, that I try to accept in this work. And I really appreciate you raising that and the struggle within that. And Professor Morgan, I love your work, and it's really got me thinking about disability. And I see your comments connecting to Professor Eaglin's comments regarding this idea of can we decouple risk from gender, race, disability, right? I mean, and also in some ways, is race a technology, disability a technology, right? Like how, we really have to expand what we really think about when we think about, technology itself. And so I think that what I find is so powerful with engaging with data from these communities is the idea that data could be decoupled from risk at all, or maybe could get us to think a little bit about this idea of if it can be decoupled. I don't see the paper as having all the answers, because on some level, because of epistemic oppression, because of the unwillingness of dominant groups in society to even engage in this, we are lacking fully in the extent to which we know if this could really bring us to a different understanding of risk. But I also believe that when looking at a lot of abolitionist community groups, they're telling us that we really just need to stop thinking about risk. And I think that's really important. And in terms of operationalizing and how do we figure out the we, I think that's a very fundamental question. I mean, it's so easy to create an institutional structure, we could even imagine one, that just allows for the most powerful people in a marginalized group to be the ones that are in control of, thinking about this question of engaging in a new kind of algorithmic construction, which then risks perpetuating inequities that already exist within the group. And this is something that I've really struggled with in my prior work in democratizing potential of algorithms. I discussed the idea of the creation of bail commissions composed of members from racially marginalized communities, and thinking about the idea of creating new institutional structures that would work alongside community groups, and thinking about the idea of those structures essentially being composed in ways that thinks through these questions of different kinds of marginalization. But it's not perfect. I think we have to accept as well that as we're thinking about this question of governing structures, there are so many ways in which current governing structures do facilitate power inequities that exist. But I take your invitation, Professor Morgan, to think about the governing structures of abolitionist community groups who've really thought through this issue and thinking through an institutional arrangement that could work. And so thank you so much, Professor Morgan, for that invitation to think about abolitionist epistemology. And I think in future drafts, I want to pivot to make it clear how I'm in communication with that. And Professor Tusi, thank you so much for your comments, raising George Floyd, raising what the extent to which the data from police, as an example, is not credible, but is given credibility not only in algorithmic construction, but in everything, right? And when we think about police reform, we think about police reform often using police data, despite the fact that, as you mentioned in your comments, that this data, it has been proven study after study to be inequitable, to not be credible, and to essentially map on to stereotyping of members of various marginalized communities. And your work, particularly, Police is Not a Good, it's an amazing paper that I'm so excited when it comes to print, just really tackles this question about policing. And of course, what comes with that is the fact that when we rely on that data, we are ensuring that as that data influences public safety, that we're not actually facilitating true public safety, which I think your work has really highlighted in the policing arena, and it's in your work has been really influential on my work. And I think that, and I'm silent about this in the paper, because one of the things I think about in thinking about this question is giving communities the choice to engage in algorithmic construction and what terms with respect to the knowledge sources that they're going to use. But in terms of my viewpoint on it, I don't think that we should be using any data from carceral knowledge sources. I think that, and as you've said, policing, and there's been so many studies about the court system, the pretrial services agency, all this data is not only just affected with racial, gendered, class, disability, other kinds of inequities, there's no way to extract it from it, right? And so in thinking about this question, to me, I see my paper as pushing us against that. But at the same time, I think it's important to recognize that is there, and this is what I gather from your, what I think important thread for thinking about this question is it possible to imagine, and I think this links your comments with Professor Egan's comments with Professor Morgan's comments, is it possible to really truly imagine utilizing data that is not infected with all of these inequities? And is it really possible to imagine that that data being part of an algorithm that would be part of a criminal legal system that would actually push us towards public safety? And I think and engaging with abolitionist epistemology pushes us to the conclusion that it is antithetical to think about. Oh, sorry. Oh, I saw something strange happen. Sorry about that. It's antithetical to think about the idea that the criminal legal system itself can produce safety. So we need to push ourselves towards abolition, right? And so I think that that's a really important thread that's come through in all of your comments. And so I want us to open it up, of course, to questions from the audience, but I really just want to thank Professor Egan, Professor Morgan, Professor Tusi for their comments, and really encourage the audience to look at their research. It's been so important for me, and I think for so many others, to really start thinking about these questions.
Thank you so much to all of you, and I really want to thank the commentators in particular. I just really want to honor the contributions that you're making, the incredibly hard work of kind of entering these difficult and often hostile spaces and refusing the really heavy discipline that tends to channel almost everything that you try to say in a critical and major, significantly radical way back into tinkering at the margins of these systems. So I just really want to kind of emphasize the value of kind of looking at the work of these women, what they've written in that US context, and for all of us who are listening now to think about, what does this tell us about our own work? What does this suggest that we're missing in our own work? And particularly in terms of thinking about technology facilitated violence, hoping that we can just never address that topic without recognizing this state facilitated violence as such a significant part of so many women's lives, well beyond the interpersonal. So I have two spaces where people can put questions. That includes just the regular chat, and it also includes the Q&A, which I think is open if you want to put things there. I think Jane, okay, so I have a question from Professor Bailey, who's one of the co-organizers, and I'll give her the privilege while we wait to see if other people want to wade in. So I think that what she's, let me just read this together. Sorry, guys. Okay, so basically, I think what she's asking, is it possible to imagine algorithms in a way that wouldn't operate by reinforcing the so-called past? So this is, I think, kind of conceptualizing what algorithms actually try to do, which is take past activity and then project it into the future. Is there a way to imagine something other than that?
That's a really important question. I think that is the way in which algorithms have currently been conceptualized, and the way in which algorithms have become popular and proliferated. I think a lot of scholars have pushed this notion that when we think about algorithms, we need to be thinking about big data algorithms that make connections about past behavior, past events in order to predict the future. But I don't think that's how algorithms have to be thought about. I mean, an algorithm is just a set of rules, and we could imagine a set of rules by communities as a way to think about how they might want, to the extent that they want the criminal legal system to operate in their neighborhood. So I think that that is a very important reconceptualization. And what I take from that comment / question is, can we actually imagine that type of reconceptualization actually being accepted on the ground? And I think that's a really hard question. And I think when we think about, epistemic violence, when we think about the marginalization of these communities, it's really hard to imagine, the state taking that on, right? Or allowing for that to happen. But I do think that it is possible to decouple the idea of how algorithms are understood now from a different understanding of algorithms.
Well, I think there's a way in which, and I don't know if any of you want to pick up on this, that question really raises for me the sector in which I think most about this, which is really child welfare, and how repeatedly anyone who works in the area of child welfare has suggested that rather than spending all that money on algorithms, we should provide resources like housing and funding to parents who are involved with child welfare, because the vast majority of them need that. And most of these most of the ways that these systems that use algorithms are set up is the past actually is the future, because none of these people are going to be offered anything other than what they've been offered in the past from the state. And I think that's another way to think about what if the state actually wanted to change the outcome of risk by doing something other than incarcerating people? What kind of needs would we think about that would be useful? I don't know if that's another way to think about Jane's question.
And I think, I think that's really helpful. I think something that's I find is important in thinking about this question of reconceptualizing algorithms, thinking about the question of what data we use, is the idea of this is a second best option. Like, I don't believe that the prescription I've laid out is the best case scenario. And, Professor Eaglin has mentioned this before in prior work, like what would it look like if we took, for example, New York City spent over about, I think, $3 million on revamping their pretrial algorithm. What would happen if they spent that time instead engaging in social programs? What would have happened instead if they actually tried to provide supports? Assuming we keep pretrial system the way it is, provide supports for those who are currently pretrial, right, to actually have them to be able to have cell phones so they can come to court on time, right? What would that look like? And instead, the $3 million we spent to revamp this algorithm. And then also, countless, cities have spent a lot of money towards these algorithms instead of towards actually engaging in resources. And the reason for which we see that is because, and I talk about this kind of in a small part in my talk, is part of this neoliberal agenda of, maintaining these logics, particularly carceral and racial logics, while keeping it, quote, cheap, right? Or making it cheaper. And it's not about actually really engaging with, why do we have incarceration? Is incarceration necessary for public safety? How could we actually really think about creating a public safety that does not include the criminal legal system at all, or maybe has it, but in a much smaller way, right? And so I think that's such an important contribution, Professor Lawrence, and that's why I just think it's important to think about even in thinking about my prescription, it isn't the best case scenario. It's still a second best option.
Maybe a quick reaction to thinking about, again, the question of the construction of risk in some senses. And I think about this when I think about disabled individuals and their entanglements, if you will, with the criminal legal system. In some ways, the factors that go into identifying disabled people as a class as risky are in part related to the systemic divestment or the failure to invest in in-home or community-based sufficient mental health treatment supports and affordable and accessible housing, and the provision of a social welfare net that prevents people from slipping into poverty. So these don't just exist along one axis. And so when you think about the fact that something like 40% of individuals in the US have a diagnosed disability that are incarcerated in jails, And it can be as high as 1 in 3 in some jurisdictions. In the carceral space that are prisons, it's about 30%, 26% have an identifiable diagnosed disability. And here in the States, given access to healthcare issues, the diagnosis for individuals that are low income, racially marginalized is high, considering that kind of social political context. So in many ways, I think your question as to like, what is the provision of need, just sort of makes me think that the system isn't really oriented towards that purpose, right? It's sort of, I think it's, has been alluded to earlier, the process is the punishment, the process is about regulating those that we've deemed marginal, those that we've otherized, et cetera. And it's not really just to throw jargon at you, but it's to really show like, what are these systems about? Like we can throw algorithms on it to, as Professor Okedebe said, make it more efficient and to use limited resources carefully, but you know, it's missing kind of the heart of the problem if we just sort of think about meeting needs in this existing structure. It fails to kind of get at the root function of these systems collectively, as has been alluded to, the family regulatory system, to draw from Dorothy Roberts' work, the criminal legal system. And I think also, Professor Eagle, I'm thinking about their conceptions of punishment itself and theories of punishment that have yet to be interrogated in this sort of new tech frame. So yeah, just lots of thoughts here, but I'll stop.
And sorry, just to add, Professor Tusi. Just to add a little bit, I also think it's important to also think about what tools exist, and something I didn't mention, but I think is important, is to think about the way to which, we might think not of this question of, could algorithms get us to a better part, but is there a way to subversively use the tools that we've been unfortunately given, right? And is there a question of interest convergence? Derek Bell coined that. There's such an interest in having these new technologies. Are there ways for marginalized communities to subvert that to reach other ends? And that's how I see my paper, as opposed to like a better world with algorithms.
Yeah, which is a fantastic title in and of itself. I just see a comment here and a question from Professor Amani, who's just asking about the use of other, it's in the Q&A part. So what she's saying is where you have other legal protections, I think, and Vita, I'm sorry if I'm doing violence to your question, where we have other protections for equality, are they useful in terms of trying to use law to prevent these kinds of algorithms? And she mentions, given the functions of code as law, might we focus on compliance with equality, not only when reconceptualizing algorithms, but their governance? And I'm wondering, because I know that all of you have actually engaged as litigators, all of the commentators, how have these kinds of efforts to put some of this into practice fared, using various kinds of potential equality protections, whether they're in constitutional law or in other parts of law?
So I don't want to take over for Ngozi if you want to respond, but I do have a comment about that. Do you want to go?
Please go ahead, Professor Eaglin.
Okay, so I think it actually highlights one of the things that's so important about Professor Okadebe's contribution, because the framing of equality has been used to basically constrict the conversation. And I see her work and my work in many ways, specifically in the law and technology space, is saying this is not good enough, right? That at least, as we have seen, in the post-conviction sentencing context, we see it coming up in the courts. And in the piece that I just wrote for the Cornell Law Review, I talk a little bit about sort of, we could understand the court's resistance to recognizing equality sort of challenges to actuarial risk assessments is deeply problematic. But we could also understand it as the court sort of resisting the imposition, or using that as sort of a way to resist the imposition of only one single way of knowing in the sentencing context. And that's scary because nobody ever said that judges were perfect. And, I think that it's unfortunate that like the framing one of the things that I see Professor Okodegbe's contribution is doing is saying, part of the reason why we're stuck with this frame of better than, judges is because of the data. And it's this framing of understanding the problem where people say, well, even if, as I've written in other pieces, people don't actually care if they're accurate or not because they say it's still better than judges. That's a particular conception of the problem, one that an equality or even I've seen sort of privacy law, perspectives on particularly proprietary actuarial risk assessments being sort of superimposed into that discourse in a way that really doesn't let us ask the kind of questions that I see Professor Okodegbe's project is asking, right? Like, it's not that, it's not about sort of being equal to use discredited data. It's about, epistemology. It's about sort of, what is it about the way that technology is particularly designed now that really just reinforces our understanding of the present, that we also, as I think, as Professor Susi so wonderfully described, that we already know is deeply problematic. Like, why else are we doing this? Like, why are we adopting this technology? It's not because we've got everything right, it's because we've got things wrong, right? So I think that there's this important aspect of the equality law and constitutional law frameworks that are being, embedded into it. But one of the things I love about, Professor Okodegbe's project, and I really do encourage everyone to read the paper. I don't know if it's up on SSRN yet, but when it's published, I mean, it really does, from a very different angle, sort of say, there's this big discussion about equality and, and understandings of discrimination within the framework of algorithms. And that alone is not going to cut it in terms of, addressing the deeper problems that the tools reflect. So I hope that's helpful.
And I'll just add one quick comment that, considering where equality jurisprudence is in the United States right now, I'm not even sure that would be a benefit. It might even be a harm, right? The ways that it could be constructed, given the types of intervention that we actually need. I wonder, let's say we construct an algorithm that is, just uses community sources of knowledge, decides not to reflect only on the past. As Professor Okodegbe reminded us, algorithms are just a set of rules, but yet these rules we use pretty much do what the system's always done, right? And so let's imagine we have a radical algorithm. The quality jurisprudence as it is may be used to take down that type of algorithm or say that it's too race sensitive or, whatever the case may be. So, I guess, we have to deal with that jurisprudence as well. But I see we only have a couple minutes, I guess, for Professor Okodegbe to give us some remarks.
Since we only have a couple minutes, I really just want to echo what Professor Eaglin and Professor Tusi have said, and just kind of add that, there's a great article by Professor Jason Bent about how and though I discuss in my talk and the paper the problems with technical adjustments to algorithms, but even those adjustments might violate equal protection. So as Professor Tusi was saying, the state of equal protection law in the United States in some ways actually get us away from even being able to contend with this problem, as opposed to really can be seen as a solution, which I know is a bit different from the situation in Canada. So.
I will say that I concentrate on Canadian equality law, and I'm not that hopeful about Canadian equality law doing really important work in this area either. But I thank you so much, all of you. I'm trying to respect the boundaries of the working day in this very strange environment. I'm going to close now. Thank you so much, because I think you've really given us some food for thought, both in ensuring that we understand the scope of technology facilitated violence broadly rather than narrowly, but also now so many questions about how this framing intersects with, particularly in terms of violence for intersectional communities. So women, for instance, who are living in over-policed communities, how did they then engage with the perspectives that Professor Okodegbe has brought, right? So how might within communities, and I think this relates to constructing the we, how does the internal we want to deal with risk and safety? So questions of both risk and safety. And I think those are really important and challenging questions. And certainly, I think Professor Eaglin already said, we're not trying to reinvent something we're doing well. We're already doing this very, very badly. So that is providing women with safety, particularly women in marginalized communities, actively harming their safety and definitely not protecting it. So thank you so much for all of this work. Ngozi, thank you so much for being willing to come back and for bringing your amazing commentators with you. Please join us tomorrow for our last public lecture event of this series. It will feature Professor Nicola Henry from the University of Melbourne. She's going to talk about her work on technology-facilitated domestic violence against immigrant and refugee women. And the commentators will be Deepa Mathu, who you may know is the executive director at the Schleifer Clinic for women who are survivors of violence, and Yiman Louis, who is a PhD candidate at RMIT in Melbourne. So please join me in thanking the panelists again. I know that when we close this, everyone just disappears into the ether and there's no like handshaking or thanks or exchange of anything. So let me say to the panelists briefly, we will be back in touch. We're not just abandoning you, but I hope you all have a wonderful evening. Thank you so much to our audience. And Karis, did you have anything you wanted to add?
Only to echo your thanks and to say how much I enjoyed that conversation. It was just terrific, and I'm so grateful that you took the time to be here today and everybody was able to stick with us in spite of the tech problems, and I really look forward to carrying on the conversation. So thanks again.
Thank you very much. Bye-bye.